And I'm your host, Jim Cunningham. I'm going to be talking about how Prop 19 takes away Prop 13 for your kids and what you should think about doing now before February 16 of 2021 when Prop 19 becomes effective. This is a disclaimer. I'm a lawyer. I'm talking. This is not legal advice. There's no attorney-client relationship. I'm not suggesting that you do something and go out and do it. I'm just giving you my thoughts on the change in the law and action steps that you can take before February 16, 2021. There's a Q&A button. If you're watching this on YouTube, on a recording, then obviously that Q&A is not going to work. But for those of you who are attending live, go ahead and put your questions in the Q&A and I'll answer those as we go through the materials here. I'm Jim Cunningham. I am the owner of Cunningham Legal, 25 years experience. We have offices in the three big areas in Southern California, the Sacramento Capital Region, Bay Area, and Southern California. I'm a certified specialist in estate planning, trust, and probate law. There are a lot of Vistage members on this particular webinar. I've been a Vistage member since 2012. I'm also a California real estate broker. This is our team of lawyers. That's me, and we've got 6 other lawyers in our firm. All we handle are trust and estate and property tax matters. That's it, right? So we're helping people pay less tax and helping people through this wealth transition process and minimizing not only property taxes, but also income taxes, capital gains taxes, and death taxes. So what just happened? We had an election last month and Prop 15 did not pass. Now it's very important. There were 2 propositions. Prop 15 got a lot of attention in California. So Prop 15 was the initiative that said, hey, let's reassess all commercial and industrial property. That went down to defeat, but it did get 49% of the vote. So 49% of the vote is a big percentage of the vote. Prop 19 did pass with 51%, so it's almost the flip. And Prop 19, I got to tell you, a lot of lawyers were not paying attention to Prop 19 because Prop 19 is really good for homeowners, but it also does take away a very valuable benefit that you can leave your children. So Prop 19, I want you to approach this with a beginner's mind. Anything that you know about the property tax system in California, I want you to sort of gently empty your mind and be ready to learn, because I will tell you, I've been practicing in this area for 25 years. This is requiring a rewiring of my legal brain. And I've been meeting with a lot of different lawyers internally, also various study groups across the state. And we've all been saying to each other, we're looking at each other, we're like, wow, this is like studying for finals in law school, except it's going on week after week after week after week. So this is a very tough puzzle that we're trying to sort out here. So understanding understanding Proposition 19 requires an understanding of Proposition 13 and an understanding of Proposition 58. I know it's a lot of numbers to throw at you, but we're going to cover these. We're going to break this down. We're going to talk about Prop 13 first. Now, in this example, mom and dad buy a home in Cupertino, which is near the Apple headquarters. Of course, Apple's headquartered in Cupertino. The property was purchased in the 70s for $50,000. The property is now worth $2 million. So huge increase in value. The property is assessed at $120,000, and I'll explain why the assessment is so low. The taxes are about $1,500 per year. Now, Prop 13 caps the taxes at 1%, but many counties and even cities have the ability to add on additional taxes. And so what you see in the real world is property taxes range from about 1.1 to 1.25%. So the current property tax structure in California, I don't know any other place other than California that does it this way, and it's kind of a screwball way. Property is assessed at 1% of its fair market value when a change in ownership occurs. A change in ownership includes a sale, pretty obvious, a gift, sort of obvious, and death. And that's the one where people, I don't think, pay enough attention to. Death constitutes a change in ownership. Thereafter, by an amendment to the California Constitution, Prop 13, property taxes can only go up in accordance with the California Consumer Price Index, and they can only go up 2% a year. Now, there have been a lot of other laws passed. Basically, the property taxes pretty much always go up 2% a year. And I'm not going to get into why, but when we model this out, when we're forecasting in the future, the value of Prop 13 for your kids, we assume a 2% increase per year in the property tax, the tax base. So this annual cap on this 2% annual cap on the property tax increase is decoupled from the value of the real estate. And so real estate goes up 4, 6, 8%, even more. The closer you are to the water in California, the more the properties tend to appreciate. Homes in Santa Barbara tend to appreciate faster and more than homes in Fresno. And I'm not, dissing Fresno at all. It's just the closer you are to the water, frankly, any water, the higher the property values, just on a high level. That means that real estate have lower property tax bills than their next door neighbor. And this applies to homes. This applies to commercial property. It applies to industrial property. It applies to multifamily. It applies to all real estate in the state of California. And something to know is everyone is protected by Prop 13. I talk to so many people and they say, if you bought your house before 1978, you're protected. No, that's wrong. Prop 13 protects everyone, not just the people who bought a long time ago. Then in the 1980s, Prop 58, this let the parents transfer their low Prop 13 taxes to their children when there's a change in ownership, typically death. And the kids, when those children die, and then the grandchildren inherit the property, they can keep those low property taxes too. That is kind of mashing up Prop 13 and Prop 58. So your Prop 13 taxes can go from one generation to the next as each parent dies and leaves it to the children. And remember, a change in ownership does include death. Death is a change in ownership. So a parent can give their property Prop 13 tax base to their children when there's a change in ownership, and they can give a home of any value and up to $1 million per parent in assessed value. So if there's only one surviving parent, it's $1 million. If there are two parents, it's $2 million. So it doesn't matter if you have 1 or 10 kids, it's the same amount. It's not a per beneficiary or per child exclusion. It is a per parent exclusion. And what we're talking about here is assessed value. We are not talking market value. And many of our clients, they maybe bought a commercial property, 40 years ago for $500,000. That could be worth $10 million now, right? That's not uncommon. And so if that property were reassessed, the property taxes would go up from, $6,000-7,000 a year to, $60,000, $70,000 a year. Well, actually it would be about $100,000 a year, $110,000, $120,000 a year on a $10 million valuation. So Proposition 13, a Proposition 13 trust is what we're going to be talking about a little bit. And I saw some questions coming in, some technical questions looking like from a lawyer. This is a descriptor for a whole group of trusts. And a Prop 13 trust allows a parent to pass the Prop 13 taxes to the children now, preserve Prop 13 for their lifetimes, for the children's lifetimes. And the problem is this has to be done before February 16th. The actual deadline is February 11th because February 15th is a holiday and the assessor's office is closed. It's a Monday. And then February 14th and 13th are the weekend and the assessor's office is closed. And February 12th is also a holiday and the recorder's office is closed. I'm sorry, not assessor's office, but the recorder's office is closed. So these deeds need to be signed, delivered before February 16th, and ideally recorded before February 16th. The parent is the grantor. The parent is the person setting this up. The children are the beneficiaries, and a change in ownership occurs. You file your claim for reassessment exclusion between parent and child. Whether there's an adjusted cost basis at death, we'll get into this. This is kind of some bullet points I'll be discussing later. Whether there's an adjusted cost basis at death is case specific. And I would say there are no one size fits all approaches. Each of these plans that we're doing for clients, and we've met with many, many clients so far, each plan super highly dependent on a much broader set of facts than a typical living trust. We do have a YouTube video. I would encourage you to go to our YouTube channel and subscribe. The subscribe button is on the lower right-hand side. We have this video here. We've gotten, to date, over about 6,000 views in about 3 weeks. We go through about an hour of content and there's another hour of questions. And so a lot of people are getting a lot of value out of that. Also, if you subscribe to our YouTube page, you'll get on our feed for additional YouTube videos as we release more content. And I will say, this is a work in process, right? We are developing strategies and we're just getting now to the point where I think we're close to finalizing the strategies that will work. So if mom and dad die before February 16 of 2021, Remember, Prop 19 is effective for the parent-to-child issue. It's effective February 16, 2021. Prop 58, the parent-to-child reassessment exclusion, lets the kids keep the parents' low Prop 13 taxes. So this means the taxes stay at $1,500. They don't go up to $24,000, because if the property was sold to another person, the property would be reassessed and the taxes would go up to $24,000. So this is a really big benefit. And the other benefit is, remember, that $1,500 tax bill only goes up 2% a year. The $24,000 tax bill also only goes up 2% a year, but 2% of $1,500 is a lot less than 2% of $20,000. And that is a snowballing effect. And so over time, if you model this out on a spreadsheet and you discount for, the discounted present value, this is a very compelling for many of our clients. And it's not compelling for a lot of other clients. And here's kind of the fork in the road. If your kids are going to sell everything when you die, then Prop 19 doesn't matter, right? Prop 19 is not taking away your Prop 13. It's taking away your kids' ability to inherit your Prop 13. So what if only one of the three kids wants the house? This is a little tricky. If let's say a trust administration, mom and dad set up a living trust, they distribute the property to the three kids. One kid buys out the other two kids. Guess what? 2/3 of the property will get reassessed. That means the property taxes will jump from $1,500 a year to $17,000 a year. They won't go up to $24,000 because only 2/3 of the property is being reassessed. And savvy attorneys, and that would include our firm and many other firms who know how to do proper trust administration, they know to effectuate what is basically a buyout of the other beneficiaries prior to distribution. There's no reassessment, and the property taxes stay at $1,500 a year, and they don't jump to $17,000. This is pre-February 16, 2021. So if you recently lost a loved one, if you're going through this process, certainly reach out to us. We can help you with this. But bear in mind, there's a difference if you do this inside of the trust versus after it's distributed. So it may not seem like a big deal to do it inside of the trust versus later, but it quite frankly, it is a big deal. So if mom and dad die after February 16, 2021, I want you to pay close attention to this, because this will be the law February 16 of 2021. The parents leave the parents' home to the child, a child. The child must claim, it has to be the parent's home. So it means if you look at the tax bill, the 2020-2021 tax bill, the parents have to be claiming their homeowners exemption. That's the $7,000 tax exemption. If they aren't claiming that, and I can tell you, I was on a Zoom meeting with some clients this week, and somehow the homeowners exemption just kind of fell off. It just went away. And I said to them, look, this is really important going forward. If you want to have a parent-to-child reassessment exclusion, it's a throttled back parent-to-child reassessment exclusion where the parent can leave the low Prop 13 taxes to the kid. You have to, as your parent, you have to have you have to have the homeowner's exemption checked. Likewise, the child has to make that the child's home, right? And the child has a year to claim the homeowner's exemption. And I can tell you, in the real world, very few clients want to move into their parents' home. Most people already have a house. They're like, I don't want to move into my parents' house. I might want to rent the Cupertino house out, right? Keep the low Prop 13 taxes, because a $2 million house in Cupertino is going to pay, about $2,000 a month in property taxes versus $1,500 a year. And so if the kids hold on to the property, that economic benefit basically transfers to the kids. So going forward, what's the rule going forward? After February 16, 2021, it has to be the parent's house. The kid has to move in there, and the kid gets the tax base plus an additional $1 million in value, in market value. So in this case, that brings it up to 1.12 million, but the house is worth 2 million. That's a difference of 880,000. That difference gets reassessed. So let me say that again. This rule where the parent inherits the property from, or the child inherits the property from the parent, and there's no reassessment, that goes away February 16 of 2021. And so now what we have is where the parent can leave it to the child, but the child has to live in the home as their residence for how long we don't know. We'll know more once the legislature convenes and passes legislation. But at this point, we know that this exemption is limited to $1 million. And so in this case, the taxes go up by $11,000 a year to $12,500. And, that may be enough of an increase in taxes where the kid says, I don't really want to live there. I'll just go someplace else. But you'll see why the kid may want to keep this property as the residence and later sell it. And we'll get into that. But if the parents have more than one child, it's possible the taxes could go higher. Again, we don't know because this is parent to child. We're not sure if you can buy out a sibling like in the previous examples, but there's a lot of, we don't know in here, but we will know next year. So what if mom and dad sell the house to somebody else? What if they sell it? What happens? And this is where the change in ownership under California Revenue and Taxation Code Section 60, there is a 3-pronged test. Now, if you're not a lawyer watching this or you're not a CPA watching this, you might go, I don't know, why are they talking about this? This is where the Board of Equalization, who manages the assessor's offices essentially and tells them what the rules are, this is what the assessors look at. Is there a change in ownership? So when you want to keep Prop 13 in your family, you do need to trigger a change in ownership. And a change in ownership means the parent has to transfer to the child a present interest, and the child gets the beneficial use of the property, and it is equal to the fee interest. Now, just parenthetically, what is a fee? A fee is a fee interest is, and under English law, this word that you would theft property. There was theft of property. It was a transfer of land, giving the new holder the right to sell it and pass it on to the heirs. It was a total relinquishment of the transfer of all rights. This is Code Section 60, and this is going back to the Battle of Hastings, 1066. Theftement could only be made of a fee, which is a fief, and theftement derives from fee with the meaning off, meaning give away, so fee off. So that's what the term fee means. That's a legal technical term. But certain transfers aren't changes in ownership. Transfers between spouses, not a change in ownership. Original owners, we're not going to cover that. We'll cover that a little bit later. Life estates, leases less than 75 years, not a change in ownership. So for attorneys who say, yeah, well, I'll just have my client give the property to the kid and the parent keeps a life estate. That's not going to work. When the parent dies, that's when the change in ownership occurs. Or if the parent says, I'm going to reserve an estate for years. I give the property to my kid, but I'm going to keep the property for 10 years. Well, that's for accountants out there and lawyers. That's what a CUPERT is. And the change in ownership occurs at the end of the estate for years. So property is reassessed unless, when there's a change in ownership, unless a reassessment exclusion applies. And this is really important because there is a parent-to-child reassessment exclusion until February 16th. So another couple buys the same residence, stays for years. This is where they transfer the fee. They're living in the property. They can resell it. They can leave it to their heirs. This is a new buyer. The property's worth $2 million. It gets reassessed, and the new buyer pays $24,000 in tax because there was a change in ownership. So I want you to start to familiarize yourself with changes in ownership. Now, if mom and dad die after February 16, 2021, and the child inherits the parent's home, and the child doesn't live in the home, the property taxes go up to $24,000. That's because Prop 19 eliminated the parent-to-child reassessment exclusion in this particular case. This applies to the house. This applies to the multifamily. This applies to the building that your business is in. This applies to industrial property, commercial property. It applies to everything. So when that property transfers to your children, if you were kind of banking in your estate plan, you're like, hey, this is great. When my kids inherit this property, they'll have the low Prop 13 tax base, and they'll be able to enjoy these low property taxes and collect the rents from the property. That's going away February 16th. Okay. So what are some solutions? Can't you just give it away? Can't you just give your property away? Well, yeah, you can. It's simple. The legal fees are lower. Here's the problem. You lose control. Your cost basis, and we'll discuss what that is, your cost basis carries over to the child, subject to the child's divorce. And I can tell you, a lot of our clients' kids do get divorced just statistically. Lawsuits, bankruptcy, loss of rental income. If you give the property away and you say, oh, I'm going to keep the income, that's not a change in ownership. It does not meet all three prongs of the change in ownership requirements of Revenue and Taxation Code, Section 60. That's unlikely to be appropriate in most situations. What are capital gains? All right. Basis is what you paid for it, plus the money you put into it, your improvements, minus depreciation. And depreciation, of course, is if you have a rental property, the government says, hey, in either 30 or 40 years, this building is going to fall down. So you'll get an income tax deduction over a 30 or 40 year period. But so your sales price, your gain is your sales price minus your basis. That's your taxable gain. And at death, when a person dies and they own property, they generally get what is called an adjusted cost basis, and that resets at fair market value. Typically, fair market value is higher. Sometimes it's lower, unfortunately, but typically fair market value is higher. So many of our clients will want to wait to sell property until maybe a spouse dies. So in California, community property state, one spouse dies, the other spouse can sell all that property. If it's value that it was appraised at death, then there are no capital gains taxes. So let's talk about a sale of a rental property. So do you remember Lori's $100,000 fourplex that she bought in 1975? Now it's worth $2 million. So it's gone up to $2 million. If Lori sells now, she's going to have a huge gain. And you got to pay taxes, right? She's got this huge gain, and it's going to be taxed at different rates. Recapture of depreciation is taxed higher. Regular gains are taxed lower. Recapture of depreciation is taxed at 25%, higher than the federal 20%. There is also California income tax. As many of you probably know, California has no capital gains tax. It is all income tax. So California doesn't have a separate lower capital gains tax rate. Then there's also net investment income tax. So we're looking at a tax bill of $730,000. So this is if Lori just gives the property. She goes, Prop 19, I want my kids to have the house. So she gives the house away. Well, she's teeing up a really big tax bill. So what if Lori dies? She gets an adjusted cost basis, right? The kids sell the house, no taxes. Not a bad deal. If her estate is under currently $11.58 million, no taxes. The kids save $750,000 in tax. But it's good for the kids, not so good for Lori because she has to die to get that. And that is an adjusted cost basis at death. So should Lori give her kids the property, either an outright gift or in trust? It depends. If Lori gives her fourplex to her kids before February 16th, they may escape reassessment. And because you're limited on that $1 million exemption, right? You can, because it's not a residence, she can give the property. And if the total value of all the property she transfers, the assessed value exceeds $1 million, then there is, a reassessment, at least a partial reassessment. But here's the downside. The kids take Lori's basis on the property, her low tax basis. So if the kids turn around and sell the property, they're going to be stuck with capital gains tax. And if they keep the property and rent it out, they won't be able to depreciate it. So if she dies and then the kids inherit the property, then the kids will be able to depreciate, a lot of structure, quite frankly, and that will reduce their overall tax bill. So that's a very valuable benefit. So Lori can gift her low Prop 13 taxes now, and the kids can still get an adjusted cost basis, okay? So what we're doing here is we are using this Proposition 13 trust, and I'm going to answer a question here. It looks like a question from a lawyer. So 2 questions about your proposed Prop 13 trust. Is there any possibility of it not working? Well, yeah, in terms of messing up the ability to get a stepped-up basis. Setting aside the possibility of being eliminated by Biden, some lawyers are saying they don't think an IDGIT, an intentionally defective grantor trust, will work because the Board of Equalization knows people are trying to get around this and will just use the rules against them. Is there any possibility that after putting the property in one of these trusts, the BOE just makes or revises the rules and ends up reassessing at death anyway? There's a lot in there. Okay, here's what we are doing. And so for you who are lawyers and CPAs, there are different paths you can do. One of the structures we're working on, and we're just about done with it, is you have to be very careful. First of all, a grantor trust rules means if I set up an irrevocable trust and put property into it, typically the trust has to pay any income tax on that, right? that doesn't come in back into on my 1040. If it's a grantor trust, it comes back to my 1040. If you retain the power to substitute assets, if you retain the power to add a charitable beneficiary, I think those are two powers that are problematic because the exercise of those powers may take the property away from the child. So what we're looking at is the power to borrow without adequate security. And that is one element to get your grantor trust status. We're looking at making a completed gift to the trust, filing a gift tax return, and then reserving in the grantor the ability for the grantor to delay distribution of income. And this is very important because that brings the property back into the estate under Internal Revenue Code Section 2038. And Treasury Regulation 2511-2D says that the mere delaying of the distribution to a beneficiary does not make the underlying gift incomplete. So I went through that kind of fast, but if you're like, what did he say? We'll be recording this and you can take a look at this again. We're also working on a memo with several other lawyers, and we'll be basically pushing that out on our website as soon as we're done with that. And Justin also says, I think the San Diego assessor had a meeting and they're already saying they're not going to respect the IDGIT. Is that not an issue? There is a Board of Equalization annotation that approves sale to an IDGIT. So I don't really know what they're talking about. It would be nice if you are working for the San Diego assessor, please give me a call, reach out to us. I'd like to have a conversation with you. If any of you work at the Board of Equalization or you work at the assessor's office, please give me a call. I have had the privilege over the last few weeks of talking to some of the smartest lawyers I've ever met. We've all kind of found each other. Like I said, we're doing these study groups. It's kind of like studying for an exam in law school. It's a very exciting time to be a trust and estate lawyer dealing with real estate issues or real estate taxation issues. Anonymous asks, a friend of mine doing a deed transfer with a life estate for the parent to use while alive. Does this qualify if also filing the parent to child form and exclusion for Prop 13 benefits before mid-February? I think I understand what you're saying, which is there is a transfer by deed with a retained life estate for the parent. If that is the case, the change in ownership does not occur when the deed is recorded. The change in ownership occurs when the parent dies, when that life estate ends. And so what that means is if the mom dies after February 16 of 2021, that's not going to work. Another anonymous says legislation is still unclear about exactly what has to have occurred by February 16th. The recorder's office is already backlogged due to COVID. Is there any chance that we do a Prop 13 trust, but due to backlog, it isn't recorded until after February 16th and it doesn't work? Okay, so a couple of things on that. I know one county, I believe it's LA County, is backed up 3 weeks. 3 months, I'm sorry. So 3 months from now, we're in December, is past the February deadline. In order for real property for a real property transfer to take effect, a deed must be signed by the grantor, acknowledged before a notary public, and delivered to the trustee and accepted or delivered to the grantee, in this case, the trustee, and accepted by the trustee. On the second page of the preliminary change in ownership report, you can indicate when the deed was effective. Recordation is the presumptive date of transfer, but there is an other box you can check. And what you say is, it was the transfer happened on January 5th or whenever it was. So you can check that other box. The presumption is that recordation is the date that the property transferred, but that presumption can be rebutted with evidence. And that's the evidence that we're talking about. So here's our YouTube video. Please go ahead and subscribe to our YouTube channel. It's a great way to stay current on this stuff. We are doing a whole lot of Prop 19 webinars. We're releasing a whole lot of content as we do it. It's kind of real time, quite frankly. And we're figuring out what we think will work and what won't work. And here's the challenge that we have. All these rules are written because people are trying to avoid a change in ownership, but we want to trigger a change in ownership. So it's kind of like not knowing what a duck looks like. And somebody says, here's a picture of an elephant, and that's not a duck. Here's a picture of an alligator, and that's not a duck, but we're trying to figure out what a duck looks like. So it's a pretty challenging task that we have before us. So I've heard of another way is to change ownership between parties so each has under a 50% interest in a tenancy in common, then transfer to an LLC. Is this method valid? Yes, that is a process. You have to watch out for the step transaction doctrine. So if in step transaction doctrine said, if you took multiple steps and pressed them all into one time, that's what the assessor likes to do, is they like to take all these things that you do and push them into one time period. So you have to be very, very careful with that, okay? There really is good stuff about, I've been kind of throwing shade on Prop 19. There really is good stuff in Prop 19. And I really want you to pay attention because we talked about the bad stuff. It's like we ate our vegetables first. Now we get, dessert. This is the really, really good stuff in Prop 19. So this is our Cupertino house for $2 million. Would you rather live in this $2 million house or this $1.75 million house in El Dorado Hills, right? And have $200,000 left over. So these are, now some people might say, there's no way I'm moving to El Dorado Hills. Where is El Dorado Hills? I want to stay in Cupertino. Some people say, I would rather move to San Diego. I'm just using an example, okay? I'm going to walk you through some examples. So if mom and dad sell before April 1st, so Prop 19 becomes effective for parent-child transfers February 16. This part of Prop 19 becomes effective April 1st. And I'm not kidding you because that is April Fool's Day, but I'm not joking. So mom and dad sell before April 1st of 2020. Proposition 60 and Proposition 90 let you, if you're 55 and over, sell your home and replace it with another property in the county, a property of the same or lesser value, or transfer your tax base to one of 10 counties. I've underlined the Northern California counties, and then there are also many counties in Southern California where you can do this. And Tuolumne County is, I don't know if that's Giants or Dodgers territory. It's probably on the border. I think they're probably Giants, but that's kind of in the middle. So you can sell this property and move your tax base if you're over 55, and you can do it once. So the home you're selling, this is another one. The home you're selling must be reassessed. You can't sell it to your kid, okay? The home has to be reassessed, and it is the same market value, not the purchase price. So there's no gaming the system. You can't say, well, I'll pay you a lesser amount so I can squeeze in under the level. No, the gaming the system doesn't work. The assessors are wised up to this. They reassess at market value because that's the law. You then have to file a claim for a reassessment exclusion. So mom and dad, before April 1st, 2021, mom and dad sell Cupertino for $2 million. Forget capital gains tax. I'm not even going there. Okay. They buy the El Dorado Hills house for $1.75 million. Their property taxes go from $1,500 a year to $20,000 a year. That is a huge jump. Okay. Because El Dorado County is no longer one of the 10 counties. They were, but the Board of Supervisors voted to take that out. And also you have to be mindful of this. If you itemize your deductions, the state and local tax cap on deductions. So that's a very recent thing in the law. And as you know, it limits your ability to deduct state and local taxes. Now, if mom and dad sell April 1st, 2021 or later, look at this. This is really cool. They sell Cupertino for $2 million. They buy El Dorado Hills for $1.75 million. Their property taxes stay at $1,500 a year. This is really cool. This is the really good stuff in Prop 19. This is the dessert that I was talking about, okay? Mom and dad have $200,000 in their pockets. That's a much bigger house. They're probably going to need it to furnish it. So this is the weird thing about Prop 13. The next door neighbor may be paying $1,500 a month, but mom and dad are paying $1,500 a year. So this is good stuff in Prop 19. I've met with a lot of clients, typically younger clients. What I mean by younger is under 80, under 70. And they say, oh, we have this low Prop 13 tax base on our house. I'm really, I'd really like to preserve this for my kids. But then we start talking about this and they go, wait a minute, I might want to sell and take my tax base. So this isn't my forever house. And so this is part of the process, the counseling process we go through with clients when they meet with us about Prop 19. So let me give you another example. Mom and dad sell before April 1st of 2021. This is a slight twist on on what we're talking about. They sell their Cupertino house for $2 million and they buy in Piedmont. Now, Piedmont is in Alameda County. It's east of Oakland, kind of the Oakland Hills. Very nice neighborhood. They buy in Piedmont for $2.3 million. So they buy a home of greater value. Their property taxes jump from $1,500 to $27,000. Okay. That's because even though Alameda is one of the 10 counties where you can transfer your tax base from Cupertino, which is not in Alameda County, you can come into Alameda County, the property was of greater value. And under the current law, and this law changes April 1st, under the current law, the property gets entirely reassessed. But here's what Prop 19 does. Prop 19 lets you buy a home of greater value, and all you do is add that extra $300,000 to your tax base. So your taxes go from $1,500 to $5,200, not $27,000. And I will tell you, I don't care how much money you have. Money is money. And if you can pay less tax, you're going to pay less tax. I mean, there are very few clients who want to pay more tax. We do have a couple of those, but I will tell you, most people want to pay less tax. This is a huge, huge property right, folks. I think this is a real game changer for the residential market in the state of California. I think when April rolls around, you're going to see tons and tons of properties trade, way more than we've seen before, because people now are not, their feet aren't nailed to the floor with Prop 13. Certainly this is people 55 and over. There is a carve out if you're a victim of a wildfire or severely disabled. There's some other things we're not really going into. We're just kind of hitting the high points. So a recap of the benefits of Prop 19 for homeowners. With the El Dorado Hills property, the $1,500 taxes stay the same with Prop 19. They don't go up to $20,000 a year. With the Piedmont property, the $1,500 taxes only go up to $5,200. They don't go to $27,000 a year. So Prop 19 is fantastic. Let's measure the savings. What are the savings? Without Prop 19, your El Dorado Hills tax bill over a 20-year period is $486,000. With Prop 19, it's $36,000. That saves you $450,000. That is crazy. This is a huge property right. And please pay attention to this. Don't let this go. By the way, it has to be your home. So your homeowner's exemption. So your action item tonight or today, after you watch this, pull out your property tax bill. You probably need to learn how to read it. Look for the homeowner's exemption. I will give you a hint. It is a number 7,000 in brackets. That's your homeowner's exemption. If you don't see that on your tax bill, you may not have claimed your homeowner's exemption. And it was kind of comical because it takes off $7,000 of the assessed value. That saves you $80 a year, $70, $80 a year. All right, I don't know if it's worth it. But if you don't have that checked and you try and do this, your property taxes are going to go way up. So you really need to pay attention to this. So without Prop 19 on the Piedmont property, taxes go to $2,700 a year. Look at that. The difference is $528,000, even a bigger difference. So again, how many people are holding back on selling property? How many people want to move closer to their grandkids? These are people who are 55 and over or over 55. We don't know what that exactly means because that is the amendment to the Constitution is over 55. Now, I take over 55 as being, you had your birthday yesterday, your 55th birthday yesterday, and now you're over 55. But the legislature could say it's 56. We just don't know. So I think a huge number of homes are going to trade if you're in the real estate or mortgage lending business or title or accountancy business, quite frankly. You're going to be really busy with this stuff, okay? Again, over 55. I didn't mention the severely disabled, victim of a wildfire or natural disaster. I'm not sure what that means. So, I mean, if there's a fire or a flood or something, and they declare a disaster area, I don't know that your home has to actually be damaged. So we're going to find out from the legislature. They'll certainly let us know. And it's not just once, it's 3 times. It's 3 times, not just once. So I don't know how many people over 55 want to move 3 times, but it's a 3-time thing, not just a one. Prop 19 kills reassessment exemption, gone. Unlimited parent-to-child reassessment on the house, gone. The $1 or $2 million parent-to-child reassessment exclusion, you need to understand, gone. Only the home avoids reassessment, and it's limited to your tax base plus $1 million, and the rest is reassessed, and the kid has to move into the parent's home. No, thank you. I mean, I don't want to do that. I mean, we have very few clients who actually want to live in their parents' homes, unless they're already living there, by the way. Most people, by the way, most people right now that we see who keep the parents' home, they are keeping it to rent it out because it's in West LA, it's in San Francisco, it's in the Oakland Hills, it's in a really ritzy area where they can get a high rent. So Marcy asks, how does Prop 19 affect taxes on vacation rental property co-owned by the parent with two other people when the parent dies and the child inherits? So she will then own with the parent's co-owner. Yeah, change in ownership. And that one, you're going to want to talk to the co-owners on that one, because something you need to know is the property gets reassessed. You don't just reassess somebody's fractional interest. The property has a new tax bill. So, and the door swings both ways on that. So if a parent owns with partners and the partners pass away and go to their kids, you may want to look at it at a co-tenancy agreement, and you sort out who basically bears the economic burden of the increase in taxes due to a change in ownership. That's something that I think you should address with a partner. It's better to address it than ignore it. So question, Anonymous asks, if we use a Prop 13 trust and it's challenged by the county assessor as something that doesn't qualify, would you go to bat to defend us? Yeah, but I'm telling you, there's a term in the law that we talk about internally, and that's pigs get fat and hogs get slaughtered. We're not going to do anything that's risky. We are, if you saw these internal conversations, we are so hyper conservative on this. We are not gaming the system. We are actually making a completed gift. The idea is to make a completed gift, file a federal estate tax return, and you meet the three-prong change in ownership requirement. And then when the parent dies, there's nothing that's going to the kid that would be a change in ownership. So that's the approach that we're taking. What if the kids want to move into the home but need to wait 3 years before they can do so? You're going to get reassessed, okay? So you have to claim your homeowner's exemption. And if you claim your homeowner's exemption and you rent it out, that's tax fraud, all right? That's it's a crime, okay? If it's your home, if you check the homeowner's exemption, I think you need to live there. Now, there may be a rule that says you can claim it and, maybe be there part-time. I don't even want to go there. I'm taking a super conservative approach. I don't want anyone to misrepresent anything with any government agency. So if you can't move in there for 3 years, I think you have a problem, right? So let's talk about gaming the system. And I say this in a tongue-in-cheek way, because I don't know if this is going to work, but this is a tax lawyer's brain. This is how our brains think. A married couple has a home and a rental. The husband makes the rental his primary residence. Now, there has to be a reason to do this, by the way. So a husband and wife can each claim separate homestead or homeowners exemptions, but there has to be a reason. For example, if the husband works in San Francisco and they have a rental in San Francisco, that he makes that his primary residence because he's going to work there, even though their other home is in Walnut Creek, let's say. So there has to be a reason there. But maybe they could both sell their houses. Can they? Let's say the home is worth $1 million and it has a $100,000 tax base, and the rental is worth $1 million and has a $100,000 tax base. Can the couples sell those two properties and mash them together into one property, a $2 million property, and have a $200,000 tax base? And that keeps their property taxes at $2,400 a year, not $24,000. I don't know. This is just, this is theoretical only. This may or may not be the law, but I think there's some really exciting opportunities going forward for California homeowners and I call this gaming the system. I'm not implying that this is illegal or unethical, but frankly, it is kind of gaming the system. So another way, and this is kind of in a sense, gaming the system, but if you own rental property and your kids are younger, if your kids are under 55, or even if they're over 55, I want you to pay attention to this. It is possible to transfer your Prop 13 taxes to a kid and the property to the child before February 16, 2021, and get a parent-to-child reassessment exclusion. And years later, the child can convert that to the child's home, the residence, right? And then once that's the child's residence and they've reached age 55, that child can take that property tax base to a new home. So let's look at Mary. She gifts before February 16, 2021. She gifts $1 million rental with a $100,000 tax base to her son, Charlie. And then in 2030, Charlie moves into the rental. Charlie's assessed value now has gone up to 120,000. Charlie's now over 55 and the rental is worth $2 million. And Charlie sells that home and takes his Prop 13 tax base to a new $2 million home with $120,000 tax base. So that's using a combination of the current parent-to-child reassessment exclusion that does go away in February, and then plan a long-term plan so that Charlie can save $450,000 over 20 years. When I say by Prop 13 is a valuable property right, that's what I'm talking about. It's saving you money on property taxes. So I'm going to talk about LLCs for investors in just a couple of minutes. We do have a question. If you guys have any questions, we're coming toward the end of our time here together. What might be the downside of doing a Prop 13 trust? Oh, there's a lot of downsides. What rights might the parent be losing? What negative ramifications should the parents be aware of? Well, here's the deal. If you're not in a position to gift your property, we have been talking about workarounds and creative solutions that I think will work. But the bottom line is, if you're not in a position to give away your property, then maybe it isn't for you. I don't know. Is there a way where you can give away your property and keep the rents? No. Is there a way you can give away your property and maybe have your kids gift you back the money? I don't know, maybe, but that can't be part of the deal. But this is something that, again, case by case basis. And we have a chat. Somebody put in the chat. John says, in your other webinar, you said that a common error is when one parent dies without creating a special trust to preserve their assessment exclusion on properties which are not primary residence. Can the surviving spouse still correct that error and save the $2 million exemption in any way after the first parent's death, or is it too late? What I'm talking about there is if the property, you have two parents, we used to have AB trusts. So when one spouse died, the deceased spouse's half of the property went to a B trust, and the surviving spouse's property went to an A trust. Depending on how the B trust was written, and depending on what the surviving spouse did or didn't do with the B trust, all right, sometimes, and generally many of the times, that $2 million reassessment exclusion is preserved because the Board of Equalization views on a B trust where the deceased spouse put property in the trust, that property passes from the deceased spouse to the children, and then the surviving spouse has his or her $1 million exemption as well. Many trusts have been rewritten so that everything goes to the survivor, because we used to have this, if you had more than 600,000 in your estate, poof, huge death tax. Well, now that number is 11.58 million. So many lawyers have been rewriting their clients' estate plans. And what they've been doing is they say, you know what, you don't need to do that B trust, that bypass trust, that credit shelter trust. Go ahead and give it all to the surviving spouse. Don't set up a trust. The problem is, if it all goes to the surviving spouse, you've now lost that extra $1 million exemption. So if that's the case, the person who asked the question, if that's the case, certainly that's something we should talk about, and we can give you a concrete answer. But looking at LLCs for real estate investors, going forward, please consider using an LLC when buying investment properties, and I'm going to show you why. In this case, this is a property that's for sale in the East Bay, in the San Francisco region. In our example, an LLC is formed. The LLC buys the multifamily property for $1.4 million. Now, it's very important. The LLC is the purchaser, is the original owner of this property, not a human being, right? Not a person. It's an entity. It's an LLC. The multifamily home then appreciates to $3 million, and the tax base has gone up a small amount. Maybe it's $1.6 million or something, or $1.7 million. The three children each acquire a 1/3 interest in the entity. Under the rules as they currently are, and I don't think these are changing, there's no change in ownership. There's no change in ownership provided no one person gets control, and not more than 50% pass to one person. So if you only have one child, you might think about leaving half to the child, half to the grandchild, or half to the child, half to the child's spouse, or half to the child, half to a niece or a nephew, or something like that, right? To avoid reassessment. But this is very important. The properties must have been acquired by the LLC, not a human, and then transferred to the LLC. So very, very important. That's where the LLC is the original owner. And let's kind of model this out. What's the economic value of this? Well, assume the kids inherit the property in 2040, and So 2040, that's the year 2040. So 20 years from this year. The property tax, Prop 13 property taxes are preserved. The kids pay $536,000 in property taxes from 2040 to 2060. Let's say they hold it for 20 years. If the property is reassessed in 2040, if the parents just buy the property in their own name and then put it in an LLC, or they just buy the property and don't put it in an LLC, that's that's almost more than double taxes, right? And so you're talking about a $600,000 savings from 2040 to 2060. And I will tell you, families who wish to create and preserve wealth should consider planning well in advance. Our wealthiest clients have been planning the longest, quite frankly. So the ones where their wealth transfers to their children while minimizing taxes, those people have been consistently doing planning year over year. So action items. I'm going to answer a couple more questions. Go ahead and put your questions in the Q&A. I'm going to try and get to all of these. Mahesh asks, can I move into a rental property I own with a low tax base? It has now become my primary, then sell it and buy a new property and transfer the tax base from my rental. I'm over 55. How long do I need to live in my rental property for me to do this? I would say generally, Mahesh, yes, you can do that. I don't know how long you need to live there. I think it's case specific. But that's something where we can certainly counsel you and go over that with you. But it's very important. The numbers are important. You have capital gains tax considerations. You've got filing status if you're a joint filer or a single filer. There are a lot of considerations out there, but go ahead and book an appointment and we can talk to you about that. Anonymous asks, if we use a Prop 13 trust to transfer our residence to the child, then there's a fire or earthquake and the house is destroyed, did we lose the ability to transfer the tax base as a result of the disaster? Yeah, that's one downside. And I will tell you, this is why with the residents, we've met with collectively in our firm, many people, and we're starting to see patterns. So I'm talking to other lawyers. Other lawyers are meeting with people as well. And we kind of all talk about, hey, this is what's going on. These are the issues. I will tell you on a high level, I am probably talking people out of doing Prop 13 planning for a residence, their primary residence. I'm trying to talk them out of it, frankly, because there's so many good benefits of Prop 19. If you're a homeowner, it's just really hard for for many clients to give those up. Now, if one parent dies and the surviving spouse is going into assisted living and they're 85 years old and you have an adjusted cost basis on the house, look, they're not, Prop 19 is of no use for that parent because they're just not going to be living in a home anymore. And so, in that case, that's a sort of an example where you would look at transferring the property to save Prop 13. But again, I'm talking a lot of people out of doing anything with the home. But even if you don't do Prop 13 planning with your home, you need to know about this Prop 19 stuff. This is really cool stuff. And you really do need to pay attention. You really do need to pay attention to your property tax bill and make sure you have the homeowner's exemption. John asks, if I give my rentals to my children and continue managing and maintaining the properties, would my children have to pay me a salary? And would I have to pay income tax on this salary? Yeah, I mean, if you're working, if you're managing those properties, yeah, I think you're entitled to a management fee. You're not getting the income from the properties. You are charging, you're performing work. And as long as that transaction, or as long as that transfer of property meets the three-prong test under Revenue and Taxation Code Section 60. And as long as you're not retaining any rights in there, I think that's a perfectly legitimate way to approach this. So action items. I'm all about action items. Okay, I've listened to this. If I were you, I'd be listening to me. Okay, all right, what do I do? All right, so Anonymous asks, please clarify what a Prop 13 trust is. What are the attributes and will it preserve the parent-to-child transfer? Current property of parent is deeded to the trust. So a Prop 13 trust, the functionality, the benefits of a Prop 13 trust vary. If you have a very large estate, you will not want estate inclusion, meaning you will want to make a completed gift, or you'll consider making a completed gift and not have that come back into your estate because you don't want to pay estate taxes. If you if you are middle class, essentially, which is kind of defined as under 10 million now, you probably want estate inclusion. If you're married, under 10 million, if you're single, 5 million, you probably do want to consider estate inclusion. And those are just different types of Prop 13 trust. And a Prop 13 trust is a descriptor for a lot of different approaches, but we've internally named it that so that we're classifying what it is. And human beings like to name things, so we've given it a name. So action items. What should you do? What should your clients do now before February 16, 2021? So for those practitioners out there to save Prop 13, I would say seek the advice of an expert lawyer now. There are very few lawyers who really understand this. More and more are understanding it, and I've been completely transparent with sharing of knowledge. This is just February 16th is going to happen too fast to kind of hold on to knowledge, and I'm just all about sharing it. So here's your action item. Go to our website, CunninghamLegal.com, and set up a Zoom or a phone consult. I need you to collect all of your recent property tax bills, locate your current estate planning documents, and get that to us before the meeting. We also ask for some personal information. It is very important that you give us your personal information, who you are, who your kids are, ages, all that other stuff, and what your assets are, because we need to know what your total assets are in order to advise you which is the best path, whether it's even advisable to do anything or not. And that's kind of the point of the consultation is, it's been said the purpose of a meeting is to determine if there should be another meeting. Well, that's what this meeting is. And there definitely is value. And I will tell you, the people who have had the meetings with us at the conclusion, whether they do any planning or not, the feedback we're getting is, wow, this is awesome. Thank you. I can't tell you how many tax bills I've looked at. People have not checked the homeowners exemption. And that is so important. I really never paid attention to it, quite honestly, before, but it's very important that you pay attention to your residents and make sure you check the homeowners exemption, because all these good benefits of Prop 19, they're not available if you don't check. As I read the statute, right? They're not available if you don't check the homeowners exemption. And when the fire's coming, it's a little late to make your homeowners exemption, right? Or after the earthquake, it just doesn't work. So a question is, what if we do a Prop 13 trust, but in the future, there's a drastic reduction in the estate tax exemption under Biden, or California imposes a death tax? Could we still then complete the gift to forego a stepped up basis, or once it's in the Prop 13 trust, we lose the possibility of completing the gift? That is something I would say that's a really important issue for us, is how do we address that? We are addressing it in sort of the inner workings of the trust. We are using a trust protector in the Prop 13 trust, and the trust protector can potentially release some of those powers so that the gift is no longer included in the estate. But then once the powers are released, you might have to file another gift tax return. We're just need to kind of work on the details on that. So at the end of the meeting, you decide if you want to take further action or not. And hey, if we do work, there are additional fees, right? That's kind of how it works. So I'll leave it open a few more minutes for questions. Please check out our YouTube page and subscribe to our YouTube page. That's really important, because then it'll appear in your YouTube feed and you'll be getting emails as we have updates on this. But I'll leave it open for just a couple of more minutes if there are any questions. And I hope this has been helpful for you guys. And please stay tuned. We are going to be, as we find out, Jean says, why don't you look tired yet? Because I'm excited. This is great stuff. I will tell you, Prop 19, the more I look at this, the more I don't like it from the kid standpoint, but this is just fantastic for homeowners, because think about, your own situation. You may have a really low tax base and you may want to move, and you may want to get a house that's maybe more expensive. And now you can. It's fantastic. And now you can go to any county in California, not just those 10 counties. All right. So I'll just give it a couple more seconds. Otherwise, we will end the meeting. And thank you again. Make sure you subscribe to our YouTube channel. And we have one more question. It seems like whether or not a Prop 13 trust will work depends on legislative clarification. Do we have an idea when the legislation will be available? For example, how long after making it their primary residence the child has to stay there before they could move out? Oh, How long does the child have to stay and make it their primary residence before they move out? Great question. I don't know. And if you are in the legislative office or writing this legislation, or a legislator, an assembly person or senator, um, please give us clarification, right? And here's what I'm thinking. I'm thinking you got to maybe be in there like kind of a year, like a cycle of property tax bills, maybe a year. But here's the deal with United States. We have Anglo-American law. In Europe, they have the Napoleonic Code. They define everything. If this statute was passed in France, they would have had everything all baked in, the dates, and it would have been all worked out. We don't really have that here. So we have to wait for the legislature to pass it. But we will hopefully have an answer. I mean, that is one advantage. And bear in mind, you have to make that election within a year. So I think by the time the legislature convenes in January, and they pass a statute, that's going to be within a year of the effective date of the statute. It's going to have to be. So we have a couple more comments here. And it says, if the survivor trustee disclaims his interest in the rental properties, can a B trust gift the rental properties to the beneficiary child before February 16 and save the Prop 13 tax rate? Yes. If you're watching and somebody has passed away and there's an AB trust, you need to find an expert attorney immediately. Okay. And what I mean by immediately is sometimes there are a lot of time delays in a trust administration. You really need to seek out advice like now. Don't wait. Okay. Don't wait till February 11th to seek out the advice. Don't wait till January to seek it out. But please do yourself a favor. If somebody has passed away and you're worried about Prop 13, you need to see the attorney right away. And what we're doing with one client is the surviving spouse is disclaiming, it's a double disclaimer. They're disclaiming the property from the B trust. Okay. So it goes to the kids now. All right. And so when it goes to the kids now, the kids can make that claim for reassessment exclusion and keep the low Prop 13 taxes. If you wait until the surviving spouse dies and that surviving spouse dies after February 16th, you don't get the parent to child reassessment exclusion. So super, super important. John, I'm glad you asked that. $500 is for 1 hour and you cannot have a mortgage on the property. Should mention this. The mortgage on the property is problematic. It can be. It depends on the size of the mortgage. Quite frankly, it depends on your financial portfolio. There is the Garn-St. Germain Act, which says parent-to-child transfers typically do not trigger the due on sale clause, but we need to look at, that's where you kind of look at the loan on a case-by-case basis. I think we can get around it if the parent who's transferring the property reaffirms the debt, essentially guarantees the debt. So I think there might be a workaround, but we're working with mortgage experts on that. We're not going to, by the way, we're meeting with clients, we're developing plans. We are not implementing anything yet because we want to make sure it works. I mean, that's super, super important. When do we expect legislation to pass and be clear? January, the legislature convenes. Probably, frankly, after the February 16th deadline. That's when we'll find out. My investment property is held as a sole proprietor. How can I get it into an LLC? So here's the interesting thing. If you are not the original owner, you'll want to make an appointment with us. If you, the person who said, I've got a I'm the sole owner of a property. If the LLC is not the original owner, different rules apply. So when more than 50% of the shares transfer, the property is reassessed. There's a slightly different approach we take to that, but it's definitely doable. Anonymous asks, what if we do a Prop 13 trust, but a future proposition rolls back Prop 19? Is that is there a ripcord in the plan where we could revert whatever rights this gives up? The short answer is yes, because the property could then be distributed to the kids. The kids turn around and give it back to the parents. That's going to be a gift from the kids to the parents. Okay. But the parent to child reassessment exclusion is also the child to parent reassessment exclusion. So it's a two-way street. What if we do, okay, they're done. What is the optimal Prop 13 trust change? Will the optimal Prop 13 trust change as regulations are announced? If so, does it get amended later? Yeah, we have powers in the trust California now permits decanting of the trust. And that was effective, I believe, at the beginning of this year or last year. So what decanting, like you decant wine, you take it from the bottle and put it in the decanter. you take the assets from the trust and put it in a new trust, you don't alter the ownership of the property, but you do alter what's going on in the trust. And so potentially that is a way to address that. So with that, I will conclude. Thank you for watching this, and thank you for spending time with me. And please please go to our YouTube page and subscribe. And also, if you want to make an appointment, go to CunninghamLegal.com, and we look forward to meeting with you soon. Thank you very much.